Good afternoon, everybody. I'm hoping that this is transmitting as it should be. My name is Charlie Cory-Wright. I am barrister at 39 Essex Chambers, along with your other two speakers today, Emily Formby
Hello.
and Ashley Pratt.
Hello.
Well, that's good news because I can hear them. So with any luck, that means other people can hear me too. We are intending to spend up to an hour, it may take less time than that, we're not quite sure, to deal with the controversial and tricky area of secondary victim claims with specific reference to recent authority. Many of you will know that this is an area which has caused lawyers all over the land, and indeed laymen too, to put wet blankets round their heads to try to work out what the right answer in law in any case and might be, and how that relates to what one might broadly call common sense. It's notoriously difficult, as I've said, and therefore we've bitten off, I hope not more than we can chew, but anyway. The range of relevant issues in secondary victim claims can very simply be summarized as follows. Who can claim? In other words, what relationship to the victim do they have, to the primary victim, that is. What sort of event can give rise to such a claim? Essentially, how shocking does it need to be and in what way? What sort of exposure does the secondary victim have to that event? In other words, did they have to be there? Did they have to come upon its immediate aftermath or such like? And when and where do they have to see it in relation to any original tort? And that is the question which is concerning us today, the question of legal and factual proximity, two distinct questions, as the authorities make clear. Now, Emily is in a moment going to describe that range of issues in a little bit more detail. As I've said, our focus is on the last one, and in particular, in relation to what is thought to be a useful but can be somewhat misleading concept, two-event cases. In other words, cases where there is one event that may be the negligence, may be more than just the negligence, and another event later down the line at which damage is actually perceived by the secondary victim. Essentially, the issue that we're going to go through today relates to the difference between what happened in Taylor and Novo, which was the leading Court of Appeal case on this question, and what happened more recently in the case of Paul against Wolverhampton, which was, by contrast, a strikeout case in front of the master at first instance, an appeal by the claimant against the master's striking out of the claim, and it coming before Mr. Justice Chamberlain, who didn't obviously overturn or seek to overturn Taylor and Novo in any way. He simply distinguished it. I should add that that case, Paul and Wolverhampton, seems likely to, or at least the unsuccessful defendants in that case, the unsuccessful respondents, are seeking to have a further appeal. We don't know whether that will be successful or not, but if it is, it would obviously be to the Court of Appeal. If we have time, we will also briefly discuss the cases of Renane, a slightly older case now, which deals with how shocking is shocking and elements of causation and from a psychiatric point of view as well, and the case of Shorter, not least because we flagged that up in our flyer, and we ought to do what we said we ought to do. We ought to do what it says on the tin. So, Emily, over to you first, I think, please, for the overall legal background.
Thank you, Charlie. So I'm going to go through what, for many of us, are the familiar bedrock or background mechanisms for these types of cases. But once you start to get into the more refined points of proximity that we will come on to with Paul and Taylor and Novo, it's quick that your head starts to explode and your blood boils. So it never hurts to ground yourself in the basic principles. And one can see that is also the way that the judges approach the case, since I think it is the area of law most often where every judgment pretty carefully goes through every case that's been heard so far to ensure that they're tiptoeing through the daisies along the right pathway. So let us take our leave from the Court of Appeal and do just that. The first question is this of control mechanisms, a familiar concept. Why are they, however? It's good to remind ourselves why control mechanisms are needed in secondary victim cases. Firstly, because there are a number of possible different tort systems and they're increasingly difficult for the claimant to succeed on. There's no fault liability, so it's not strictly a tort. There's causation, or causation is the only thing that's required. Or you have causation and general foreseeability, or causation, foreseeability and proximity. And if so, as in here, what is proximity meant by in this context? And our system is really positioned between the last two. Causation, foreseeability and proximity is required. And the proximity requirement is still who is my neighbour. But that's got a very specific meaning in a secondary victim case. What does proximity mean in a secondary victim case? And helpfully, it means two things. So the secondary victim jurisdiction is an extension of normal proximity rules because, of course, they're not the immediate person engaged in the tort, that's the primary victim. And so therefore it only ever operates on the margins of tortious liability. It's the recovery in the extreme cases. And so we still need to apply the rules, but they have to be refined because you've not got that straightforward relationship of tortfeasor to whom they are carrying out the harm being the primary victim. That one step remove is what makes these cases so difficult. The best place to find the control mechanisms that operate in secondary victim cases is in Lord Oliver's speech in Alcock, one of the cases that arose from Hillsborough, and a judgment that has many issues of difficulty and highlights where policy really comes into play in the common law. But Lord Oliver's speech in Alcock sets out the control mechanisms for secondary victim cases. And essentially they are the following five. Firstly, the claimant must be closely related to the primary victim. And that's a close tie of love and affection. That's generally the easiest to determine, but it must be there. Secondly, the claimant must have been either present at the incident or its immediate aftermath. So both physical and temporal proximity to the event are required. And that's one of the areas of proximity that we're going to be looking at. The claimant must have perceived the death or the risk or injury to his or her own senses. So being told about it by someone else will not do, or having it mediated through some other mechanism will not do. And it must be the shocking event. And we'll see in these cases become very fact specific, but where you have an unfolding of something but you don't witness a shocking event, witnessing has to be both immediate and of the shocking event. And the claimant must have a recognised psychiatric injury, not so difficult now that psychiatric injury is more defined, but a grief reaction or grave distress are not sufficient. It must be a specific and recognised psychiatric injury. And that injury must be caused by shock. In the old parlance, they used to be called nervous shock cases, but essentially the shock is not the nervous shock as in the psychiatric harm, but it is the shocking event, as in it must happen to you in a sudden way. There must be a sudden perception of that injury that has been suffered from. And so that's the outline of the cases, the control mechanisms that we then apply to these cases. And in particular, we're going to be concentrating on the rather difficult and vexed question here of proximity. Firstly, Charlie's going to deal with Taylor and Novo, the first in time and the Court of Appeal case. And then Ash is going to have a look at how that then translates within that proximity rule, and how it's been determined by Chamberlain in Paul and Wolverhampton. So over to you, Charlie.
Thank you, Emily. So the first thing I think to do is to set out the facts, because these cases drive you particularly mad if you end up moving into the abstract questions of legal principle. It needs to be firmly rooted, the consideration, in the particular facts of any one case, the case you're considering. And what's pertinent here is to note what similarities there are and what differences there are between the underlying facts in Taylor and Novo and in Paul. As Emily said, Ashley's going to deal with Paul, but I'm going to summarise the facts in Taylor and Novo now. Mrs. Taylor, who was the primary victim, was injured at work when shelving fell on her. She suffered an apparently minor head injury and an ankle injury. She attended hospital and was discharged after a day or so. Some 3 weeks later, 3 weeks, note please, she suddenly collapsed and died as a result of unexpected pulmonary embolism caused by DVT, deep vein thrombosis, attributed to the original injury. This happened in the presence of her daughter, please note, who suffered PTSD as a result. There was no issue on the psychiatric evidence. The only question was, do those facts ground a claim in law? And I'm going to come back to that in a bit more detail shortly, but the simple answer to that question was no, they do not. And I would be the first person to say, on the face of it, it's surprising that they don't. Why wouldn't they? That's the natural layman's response. The Court of Appeal's natural lawyer's response is that while there is clearly a relationship of legal proximity between Novo, the defendant, with the dodgy shelves, and Mrs. Taylor, the primary victim, her daughter's claim failed because there was not a relationship of legal proximity or temporal or physical proximity between Novo and herself. And this is not simply a question of direct causation, was it caused by? It's a question of legal proximity. Are they neighbours to one another in the Donoghue and Stevenson sense? Because Miss Taylor was not present at the scene of her mother's accident at work, or at any scene that might sensibly be thought to be part of its immediate aftermath, her claim ultimately failed. That was contrary to the first instance analysis, which had been, here there are two events. Number one, the event of the accident at work. Number two, the daughter seeing her collapse in front of her at home. And on the simple two-event proposition, the claimant was suggesting in that case that the relevant event is the second event. Obviously, that's the shocking event. That's the one which you need to focus on. What the Court of Appeal found was there's a tort, the injury is complete at the first stage, the tort is complete, later on the daughter sees her, the claim fails. But as I say, I'll come back to the proximity question in a moment. Now, I'm now going to hand over to Ashley to describe the facts in Paul, so that you compare the two sets of facts untrammeled by further legal analysis.
Yes, thank you for that, Charlie. As Charlie said, I'm going to deal with the latest in the line of secondary victim claims, which is Paul versus the Royal Wolverhampton. I'm going to set out the facts, or the basic facts, and then I'm going to deal with what might be termed the simple breach finding that was made by Mr. Justice Chamberlain. Well, starting with the facts, as Charlie said in the outset, or the introduction to this talk, we have to assume, or the judge had to assume, because it was a strikeout application, that the best set of facts for the claimant, and that's what the judge went on to do. Now, the facts themselves of the accident can be simply put. I'm going to set out the dates very briefly because they are important in this, this type of claim. On the 9th of November of 2012, Mr. Paul was admitted to the New Cross Hospital with pain in his chest and his jaw, and he was discharged 3 days later following tests and investigations. More than 14 months later, on 26th of January 2014, whilst walking near a shopping precinct with his two daughters, I think one of them was arguing and one was walking in front. Sadly, Mr. Paul had a heart attack at first. The daughters thought Mr. Paul was joking. It soon became apparent that he needed urgent attention. The daughters were ushered away, and sadly, Mr. Paul was pronounced dead on the scene at the hospital. It was later found that the heart attack was caused by ischemic heart disease, and it was assumed, certainly for the purposes of the claim, that had an angiogram had been performed earlier on, that might well have caused further treatment and or surgical intervention. Now, they're the basic facts of the case. I just want to deal, as I said, secondly, with the simple breach of duty aspect of this, and taking the claimant's case, as I say, at its highest. It was taken that there was a breach of duty, of course, on the part of the hospital to arrange for an angiogram, and therefore we don't necessarily need to go into causation, but that perhaps would have needed to be assumed as well. But in effect, nothing had manifested, i.e. When Mr. Paul had left the hospital, New Cross Hospital, there were no signs or symptoms to indicate that there was any problem with his heart. Mr. Justice Chamberlain found, quite basically, as it were, that the initial tort was incomplete, and found that the completion of the tort was when the negligence manifested itself, i.e., that is to say, when the heart attack actually took place. So therefore, on a basic reading, of course, of the case, the event itself was when the heart attack actually took place. And therefore, it's probably not surprising, or it may be surprising to some, that there was factual proximity given that finding, and there was also a horrifying event when one thinks in the lines of Woolcock. As such, put simply, the control mechanisms, as Emily set out, were made out in this case. Now, Charlie, they're the facts in the simple breach. I wondered whether or not you saw any distinctions between the one event case of Paul, of course, and the two event case of Taylor.
Well, thank you, Ashley. That is the easy way of looking at the distinction between the two cases, that Taylor is a two-event case, that and as we know from Taylor, from the Court of Appeal in Taylor, you don't look at the second event, you look at the first event in those circumstances. And the question is whether there is legal proximity to the first event, if that's the right way of looking at it, or to the tortfeasor, if that's the purest way of looking at it. Whereas Paul, there's only one event on the face of it, which is the heart attack much later as a result of undiagnosed heart problems all those months before. The problem is that both cases go beyond that sort of analysis in slightly different directions. Both cases are decided by reference to detailed analysis of proximity questions, but in inconsistent ways. Lord Dyson, in Taylor and Novo, accepted in terms the following aspects of the defendant's case. First of all, he accepted that it's incorrect to elevate proximity to a relevant event so as to be the test. In other words, in that case, incorrect to elevate proximity to the collapse of the mother in front of the daughter. It distracts attention from the fact that what is required is proximity between the secondary victim, in that case, the daughter who was watching her mother die, and the tortfeasor. Once it's appreciated that the correct question is whether the parties were in a sufficiently proximate relationship, i.e. as per the general principle of the neighbour approach to analysis in tort as set out in Donoghue and Stevenson, with which we're all very familiar, it becomes clear that the answer must be no, there is insufficient proximity. That was accepted by the Court of Appeal. And thus, because Miss Taylor was not present at the scene of her mother's accident at work, or at any scene that might sensibly be thought to be in part of its immediate aftermath of that accident, there was no recovery and no application of Lord Atkin's neighbour principle. Therefore, from Taylor and Novo, the question that needs to be, the principles to be derived are as follows. The first question is always, is proximity established in that sense? It's wrong and a distracting shorthand to characterize the issue as which of the events is the relevant one. That's what the judge had done. And interestingly, it's worth bearing that complaint about what Lord Dyson's suggestion that was an incorrect approach in Taylor and Novo to what Mr. Justice Chamberlain did in Paul, because I'm jumping ahead slightly and treading on others' toes, I think, when I do this, but that's exactly what Mr. Justice Chamberlain did. In Taylor and Novo, the question was, is the relevant event the collapse of the shelves or the death? Now, that is not, Lord Dyson was saying, the right question to ask. The question to ask is there the necessary legal proximity between the secondary victim and the tortfeasor? When posed that way, it's clear that the claimant and her possible presence at her mother's side when she died suddenly 3 weeks later cannot have been within the contemplation of the defendant as a possible consequence of the tort. And bear in mind, the test for proximity in this context is whether or not the damage to the relevant claimant, in this case the secondary victim claimant, can be within the contemplation of the tortfeasor when the tort is committed. So, in my view, when that case was decided, it was difficult to see how there could ever be successful two-event cases in circumstances where the secondary victim had no link to or proximity with, either temporally, physically, or legally, with the tort itself. And that remains my view if Taylor and Novo, for so long as Taylor and Novo remains good law. It is very hard often to see how to justify the law that, as it is set out in Taylor and Novo. But that is simply one example of the many areas of this part of the law which appear to defy common sense. But so far as I am concerned, that remains the position. Now, Emily, you, I think, are going to tell us why there may be distinctions in relation to the facts of Paul and the legal analysis of it by Mr. Justice Chamberlain in his judgment.
Well, I may be, as Charlie's gently danced over my corns in this bit with his analysis of jumping from Taylor and Novo to Paul and Wolverhampton. But I may not be quite that bold as to be able to find a pathway through jurisprudence when other greater and mightier minds than mine have failed to do so. But what I can point out are some of the issues that arise and how Chamberlain has sought to deal with them. Because following on exactly from what Charlie has told us about Lord Dyson's analysis, we come to Mr. Justice Chamberlain's attempt to square it away in the case that he found before him. And he was presented with exactly the argument that Charlie's just articulated from us in Taylor and Novo, perhaps not surprisingly, on the defendant's behalf in Paul and Wolverhampton, because you would present the Court of Appeal case when you had won, wouldn't you? And so it may not be a surprise to find that the submission emphasised the importance of the overarching requirement to show proximity between claimant and defendant when dealing with Paul and Wolverhampton. But, says Mr. Justice Chamberlain, in his judgment, the appeal to proximity in this present case, in the case of Paul and Wolverhampton, doesn't assist. As Lord Dyson made clear in Taylor and Novo, as we've just heard again, the term proximity has been used in two different senses in the case law. First, the legal term used as a shorthand for Lord Atkin's famous neighbour principle, so the relationship between the parties necessary to find a duty of care of one owed to another. But the second, in the specific context of the secondary victim, the physical proximity in time and space to an event. So that is one of the control mechanisms which, as a matter of policy, the law has introduced. And Chamberlain reminded himself that when Lord Oliver spoke in this passage from his speech in Alcott, which I referred to earlier, of the absolute essentiality of showing proximity between claimant and defendant, he was using the word in that first sense, so in the neighbour principle of Lord Atkins. And he made clear later on in the same passage, did Lord Oliver, when he observed that the concept of proximity was an artificial one, which depended upon the court's perception of what is the reasonable area for the imposition of liability, rather than on a logical process of analogical deduction. So the control mechanisms in secondary victim claims are, as Lord Dyson said, repeated by Mr. Justice Chamberlain, the judicial response to how the area should be defined. So rather boldly then, in the light of that, Mr. Justice Chamberlain said, contrary to the defendant's submissions, it is not sufficiently simple to pose the question of were the parties in a sufficiently proximate relationship. So that proposition, that Taylor and Novo proposition, is not sufficient because the answer to that question is far from obvious. And more importantly, it's got to be answered not just by an appeal to basic intuition, but by asking whether the control mechanisms are satisfied. So in the case of Paul and Wolverhampton, for example, there'd be absolutely no dispute if Mr. Paul had collapsed from his heart attack on the 26th of January, so the day that he'd gone into hospital and not had his angiogram, he'd come home and had a heart attack. You may say there was absolutely no question of that being a relevant event in which each of the control mechanisms were satisfied, assuming that his daughters had been present as they were. Because of the relationship between father and child, because of the primary victim and secondary victim, because of the injury being a sudden heart attack, can't be more sudden than that. I mean, Mr. Paul walking along and he literally keeled over. A sudden unexpected shock to the secondary victim children who witnessed it, being personally present. So if they were present and if it had happened on that day, there would be no suggestion that what they had done would be sufficiently proximate and that there was a close temporal connection between the event and the claimant's perception of it. However, says Mr. Justice Chamberlain, you then have to take that concept of proximity and apply it to the present case. So having a heart attack 14 and a half months later, after the negligent treatment, how does that play into your proximate assessment? And can it or can't it? So firstly, do you have to have the event, the negligent act and the event happening at the same time? Clearly not. Clearly not. Secondly, is the collapse from a heart attack an event or not? Yes, that becomes the event. See, it's not until you've got the event of the heart attack, when you've got the consequence of the negligent act, that you've got the event that is the shocking event that is witnessed by the daughters seeing the father collapse. And that is what makes the completion of the event, and it is proximity to that event that leads to the question, says Mr. Justin Chamberlain, coming around in response to the proximity question. So he says the third possible reason why the collapse couldn't be an event is that this concept of being present at the scene of the tort, and that was very much the part of the defendant's submissions, being present at the time that the angiogram didn't take place, the time of the tort happening. But he distinguishes Taylor and Novo in his judgment because he says there you have your breach of duty and your damage happening coincidentally in time and space. You've got a completed tortious event at that place at that time, and it is a consequence of the event, in the words of Lord Dyson, that was witnessed by the daughter later on, which is why in Taylor and Novo there was no recovery. But in Paul and Wolverhampton, the consequence, the event, didn't happen until the heart attack occurred, and therefore the consequence of the event was what was witnessed, and that is what made this case one that could succeed. Now that seems to be logical, despite being a complete contradiction of what Lord Dyson had earlier said on my understanding of it, and in the way that Charlie had explained Taylor and Novo. By contradicting but stating that you're agreeing, there comes to be a decision in favour of the claimant, perhaps, or rather confusing. And one can, in passing, only have a certain sympathy for poor District Judge Moss, who had a remarkably similar case in the case of Doozy and Leeds. Now, of course, this is a county court district judge decision, so significantly further down the jurisprudential pecking order. But in that case, you may be forgiven for saying, well, it's pretty much a pre-run of Paul and Wolverhampton. Mr. Doozy goes into hospital with chest pains. In fact, what the hospital failed to do on this occasion is not an angiogram. It's a test. For the moment, I can't quite remember. They won't have a troponin, and it wasn't done. Negligence accepted, but it happens quite quickly. On the 26th of September, the negligent treatment occurs. He goes home. Overnight, he suffers a catastrophic heart attack on the 26th, 27th of September. Then goes into hospital, lingers for some time, and sadly dies on the 11th of October. Now, that does sound to be very similar in circumstance to Paul and Wolverhampton, and indeed even closer approximate time being only 24 hours between the negligent act and the second event, as Judge Moss said he was bound to find it to be, in the light of Taylor and Novo. Now, cast in Mr. Justice Chamberlain's description, in fact, the heart attack would be the event, and would be the event that led to the completion of the tort and the proximate event happening. Now, in fact, the second reason why the claimant failed to recover in Doozy was because, in fact, she didn't witness the heart attack. She only found her husband later after he was unconscious, and therefore there was not sufficient proximity within the control mechanism of witnessing the shocking event. But I have to say, in the earlier facts, it is somewhat difficult to see a distinction between those two cases. And now I'm going to hand over to Ashley, who is going to cover some of the other issues in Paul and Wolverhampton.
Yes, thank you very much, Emily. The next point, certainly I'm going to be dealing with, is the short point, but no doubt to some troubling point that arose out of Mr. Chamberlain's judgment in Paul. Now, I appreciate that some may term what I'm about to say as the obiter comments of Mr. Justice Chamberlain, but nevertheless, he did reach a decision. And that decision was in respect of the question posed, it seemed, by both parties. What if the defendant's negligent omission caused actionable damage prior to Mr. Paul's collapse on the 26th of January 2014? Now, the claimants were, of course, saying, well, of course, you can still found a claim. And the defendants were saying, no, you can't. The reason the defendants were saying, effectively, no, you can't, is because if you find that the actionable damage brought about what might be termed, and you've heard from Charlie and Emily before, as the event, then the event in Paul, of course, would have taken place when Mr. Paul had the angiograms 13 or 14 months earlier. So that would, of course, produced a loss, as it were, for the claimants, and that may well be a point that's taken in the appeal. We'll have to wait and see. Now, Mr. Justice Chamberlain came up with, as I say, quite a short point to this in answer to the question I've just raised, and he said in the decision that in a case where the secondary victims for psychiatric damage caused by witnessing it, forgive me, in a case where the shocking event is the point where the damage becomes evident, it is difficult to see why recovery should depend on the happenstance of whether, possibly unbeknown to the primary victim or secondary victims, actionable damage had previously been suffered. So he therefore goes on to hold that Taylor and Novo is no bar to recovery in the case if it's shown that Mr. Paul's collapse from the heart attack was the first occasion on which the damage caused the hospital's negligent failure to diagnose and treat his heart condition, and his condition became manifest. The important thing about that, of course, is that earlier actionable damage made absolutely no difference on my analysis of the Paul decision to the claim at all. Charlie, and just to hand back to you then, arising out of that point, do you see any difficulties here between that decision in Paul and Taylor, or any further distinctions that you can make?
Well, clearly, Mr. Justice Chamberlain himself regarded that as a potentially significant distinction. He was, of course, dealing with it, as both of you have pointed out, at the preliminary stage of a strikeout. Therefore, all the facts have to be assumed against the defendant, and also the expert evidence as to precise matters of causation and the backdrop to all of this were not articulated fully before the master, or indeed, therefore, before Mr. Justice Chamberlain. My own feeling is that it's highly likely that as the case proceeds, unless there is a successful appeal by the defendant against Mr. Justice Chamberlain's decision, as the case proceeds, there will be much more evidence about what actually happened prior to the second event on this analysis of things, which may well be pertinent in terms of the question, if it is a relevant one, was there an earlier event? Is this simply a case in which nothing happened, brackets, although it should have done, and the omission is the negligence, close brackets, or not? My own feeling is that the problem with Mr. Justice Chamberlain's judgment is that while it does identify a possible distinction and appears to light upon that distinction as the reason why Taylor and Novo is not binding, it's hard to see how that distinction avoids the need for Taylor and Novo to be binding. In other words, the fact that Taylor and Novo happened to be a clear two-event case doesn't mean that the principles enunciated by Mr. Justice Chamberlain, the principles enunciated by Lord Dyson in relation to legal and factual proximity in that case aren't relevant or binding upon the facts in the case of Paul. And it seems to me that the question of whether there was actionable damage prior to the heart attack which gave rise to the secondary victim claim, the question of whether there was actionable damage on the part of Mr. Paul prior to that, or whether there was still an actionable damage pending, if you like, without it creating a cause of action. It seems to me that that can't automatically become and shouldn't be regarded by those litigating in this area as being demonstrative of passing the proximity test in relation to a secondary victim claim. So all of that will, I suspect, be up for grabs if the matter does proceed to the Court of Appeal on behalf of the defendants in the Paul case. We will need to see whether there is permission given there. It wouldn't surprise me if there were. But I would like to add one other thing about this aspect, just in case it's not clear already, which I suspect it may be. All the three of us, and I suspect many of you out there thinking about all of this, are probably thinking, how can this be? How can this area of law be quite so intractable or indeed incoherent? I'm afraid that is a problem that the most senior lawyers in the land, including those in the House of Lords in the Hillsborough cases, Alcock and White and Frost, have been identifying for many, many years. And it is a problem that arises because of public policy considerations being the master of the incremental development of the common law. And my own view about this is that this problem is not going to be resolved unless the Law Commission recommendation that there be statutory intervention here comes about. So
I mean, I think, Charlie, wasn't it in the case of Frost when they say we really can't go any further in the common law arena? If it's going to go any further, it's got to be Parliament, and therefore we have to stop this incremental movement, for better or worse. It's too much of a sea change. Here are the control mechanisms, and we just have to jolly along the best we can, for want of a better description.
And I think the memorable phrase, "the search for principle was called off long ago," it appears in that case. I don't know whether there's anything else we should be discussing about Paul and Taylor and Novo and their relationship with one another.
Charlie, I just want, forgive me.
Yeah.
I just wonder whether or not we should mention questions, whether or not people wanted to pose questions and how we were going to deal with those. Yes,
if anyone has any questions which they would like to pose to us on the app, on the webinar, the Zoom webinar screen, please feel free to do so. We are not going to guarantee that we will come up with answers to them today. That is a very good question. Will there be any handouts? We don't have a PowerPoint and we haven't written a handout. So I'm afraid the answer to that question at the moment is no, but we can consider whether we should convert this into some sort of article which we can distribute further down the line. Well, I'm sorry about that too.
So I would say that we've got sad face, no handouts. If anybody's got any questions, we may well answer them later. The problem with handouts in this area, in particular in relation to this case, is as you can tell, it's such a movable feast and is likely to be appealed soon. Yes. But maybe we'll try and condense some of the points we've made into a sort of more discursive article.
I think the point's been made, Emily. This is recorded, so if there's anything you want to look at again, so that's a handout, as it were.
But I think the other thing we could do in the last few minutes is Charlie, maybe just look at a couple of other cases and see how the proximity or other decisions sit with that.
We said in our publicity for this webinar that there would be a bit of a discussion on the last Court of Appeal case of which I'm aware, which is Renane, which is on the separate question or questions of what is required to satisfy the sudden shock element of the control mechanisms, and in particular, what is required in the hospital context. And the hospital context is important when one's considering Paul, because Paul, of course, unlike Taylor and Novo, was a hospital case. And the reason why hospital cases do deserve separate treatment, even though Mr. Justice Chamberlain made it very plain that as far as he was concerned, the same principles should apply in relation to matters of proximity, etc., is because of the practical consequence of matters arising in hospital. And that was very much the backdrop to the case of Renane. And I'll just go through the facts of that very briefly. But I'm going to identify the features of hospital cases that are relevant here. Hospitals are places where the day-to-day work of the people there are dealing with people who are injured or ill, or if they're healthy, they're vulnerable. They go there, and they go there followed by their loved ones. The nature of any triggering event, whether due to illness or injury in hospital or whatever, may well be of a different quality to the types of event that occur in normal places, road accidents where someone is hit by a car, or a situation where someone has a scaffold pole dropping on their head, or which are by definition shocking. They're also less likely to be sudden events in hospital. They may be gradual. They may be a series of events. That's a phrase that's been used often in the cases. Also, it's in the nature of hospital visits that you can expect bad news. It may be deeply distressing or upsetting, but it's less likely to be what is required on the authorities, which is a sudden assault on the nervous system. And therefore, in that context, it's worth looking at the events that gave rise to Rename. This was a situation where the husband of a woman who had suffered from septicemia and peritonitis in hospital as a result of a negligent colon rupture during surgery, claimed because, as he had put it, he came in and he saw his wife surrounded by drips and tubes and things, and she looked like she was blown up like the Michelin Man, as he put it in evidence. He was severely shocked by this. Now, it's not irrelevant to the outcome of this case, I suspect, although in terms of legal principle, it probably ought to be, that both the wife and the claimant himself made a pretty well complete recovery from the various injuries. In her case, septicemia and peritonitis. In his case, allegedly PTSD, probably more likely adjustment disorder. And so one does not have the tragic element to many of the secondary victim cases, which tragic element, in my view, has the consequence of distorting the way the legal principles are applied. And they are, by definition, very difficult cases for judges to deal with in terms of their factual backdrop. And that's why, one of the other reasons why it's so difficult to see a coherent approach being adopted by judges. But the position in Ronayne was that because the claimant had gone to hospital expecting his wife to be ill, and what he saw was her ill in a slightly different way that he did find in a layman's sense shocking, but not receiving any of the blow to the nervous system type of characterization that would be seen, for example, by someone who saw his child or his wife or her husband, whatever it might be, being hit by a car in the street. The judge found that the Court of Appeal found that the necessary element of sudden and shock was not available. There is another aspect to that case which I think is likely to have further ramifications further down the line, which is less easy to state, which is the need to demonstrate psychiatric damage that is as a result of the witnessing of that sudden and shocking event, as opposed to something that is simply a response to the death or injury of one's loved one. And those people who deal regularly with secondary victim cases will see time and again, whether they're acting for a claimant or a defendant, a situation where the experts are being asked to distinguish in what seems to me an unrealistic way, because experts can very rarely ever distinguish with these things scientifically, between that which is the consequence of grief, that which is the consequence of the sudden and shocking event, but which would not have occurred had the negligence, had the sudden and shocking nature of the incident been seen. And In those circumstances, regularly psychiatric reports are put before the court on one side or the other, trying to identify the extent to which those factors can be seen to be exclusively attributable to the sudden and shocking nature of the event concerned. And in my view, that is asking clinicians to do something which they are, generally speaking, not equipped to do, not because of a lack of expertise, but because it's simply very, very difficult to disentangle the strands of grief reaction, extreme grief reaction, and PTSD and adjustment disorders, etc. But that will, par excellence, be the sort of issue that arises differently in each case, and therefore it needs to be analysed in terms of the particular evidence in that case, and it's probably not helpful for someone like me to make airy pronouncements about it beyond what I've done already. So I shall cease and desist from doing that. On that note, I'm just sorry.
Well, shall I just pick up there, Charlie? Because I was going to then have a little look at the case of Shorter, being another hospital case, and actually by doing that, I can answer. We have a question about public policy playing a role in the appellate decision in Paul and Wolverhampton. And the question asked is, you know, as Charlie said, in this difficult area with the moving forward, how do we see public policy playing a role in the appellate decision, given the potential for claims against the NHS for misdiagnoses to expand? Well, obviously, the first thing to say is, at the moment, there isn't an appeal. So at the moment, it stops with the Chamberlain decision, which of course is a strikeout on assumed facts. But in fact, the public policy point was brought into play in that case by the defendant as one of the reasons why the strikeout should succeed and Taylor and Novo should be followed. And indeed, we know from the beginning of that judgment that this case had been brought forward because there were several other similar cases in the wings waiting for a determination on the outcome. Perhaps not surprising, misdiagnoses leading to subsequent problems being very much a feature of a clinical negligence case. And so one would imagine that would also extend to family and friends in the secondary victims. What Mr. Justice Chamberlain said about that was that he didn't accept a submission, a floodgate submission. And I suppose a simple way of looking at it is, just as you have cases where you have a misdiagnosis with a subsequent consequence and you have to prove that the failure to do something, the omission of action in the hospital, was what caused the later development and material worsening of the clinical disease that gave rise to the claim. And that, we all know, can be a difficult proposition for a claimant. That's got to be your first proposition before you move on to having your secondary victim claim, because if you don't have a tortious action, then you couldn't have anything upon which to piggyback your secondary victim consequence or your secondary victim harm as well. But also, what Mr. Justice Chamberlain said was, beyond that, was he doesn't see there being a kind of flood of cases as a result of his judgment, because of course at the macro level you still have the control mechanisms, and the control mechanisms are specifically countenanced to deal with the public policy events or the public policy side of things. And he felt that in principle, defendants are liable for secondary victims for psychiatric damage caused by witnessing events to the primary victim, and they are controls, and those control mechanisms exist, and the decisions that he has made in this instance and all the other instances are very fact specific, that either do or don't slot into those control mechanisms. So the floodgate proposition, he felt, would only really be changed if one of those control mechanisms was changed. And he specifically mentioned Renane, which we've just heard about from Charlie, and also Shorter. And what he said was cases like Shorter and Renane show that bringing these types of cases won't be easy, particularly when events occur in the clinical setting for many of the reasons that Charlie has given. And what I was going to do, which sits quite comfortably with that question, was just have a quick look at Shorter itself. And that happily then concludes the bullet points and what we said we'd do on the tin. So I might be able to both answer a question and do that which I said I'd do at the same time. Let me just, I'm sorry, I'm now just having a quick look at Shorter.
While you're checking,
Yep.
Can I just mention one more thing in relation?
Yeah, please do. Yeah.
The question you've just answered, and the question is, that just in case anyone needs to remember it, how do you see public policy playing a role in the appellate decision, given the potential for claims against the NHS for misdiagnosis to expand? And that's obviously a question about the possibility of any public policy role in the Court of Appeal in that case, if the case goes that far. And Emily has given a very clear answer about that, but I would expand it upwards a little bit. In other words, even higher bird's eye view. This whole area of the development of the law in secondary victim claims has always been a public policy compromise between two purist decisions. The purist decision that says you can't have legal proximity to someone who simply isn't there, and therefore all secondary victim claims, unless they are people who would be within the contemplation of the defendant at the time of the tort taking place, and there's your obvious car crash case, should be barred. That's on the one hand. On the other hand, the extreme position for a claimant would be if you can prove that you have suffered genuine psychiatric damage as a result of witnessing an event which goes beyond that which you would normally, if you satisfy the requirement to be someone with close ties of love and affection, and you have see a significantly shocking and distressing event with sudden impact on you, you should be able to recover whatever the position, whether it's one event, two events, or whatever. Now, the public policy element to this is holding the ring between those two arguments. Precisely because it is a public policy consideration, it's hard to see how it can be derived from pure legal analysis. So the answer to the question is, it seems to me, there is a role for public policy, either to limit the claims recovery by saying thus far and no further, or for expanding it on the basis that the only just result must be for this sort of claim to continue. The problem with public policy is that it tends to be an excuse for getting around legal analysis. Sorry, that's a slightly tangentious way of putting it. But I mean, in other words, public policy is like a trump card, which you can play in order to get out of the problem that the legal principle has given you.
Charlie, anyway. I just wonder, based on that, what your thoughts are, whether or not public policy had any effect on the decision making in Paul. I'm sorry if that's an unfair question, but just what your thoughts are on that.
Sorry, to what extent has public policy rise to this?
Because it's an unusual.
Well, I think I think there is a strong sense amongst certain practitioners that Taylor and Novo was wrong, and that it leads to unjust results, and that therefore there should be public policy arguments advanced as to why that's so. And until someone gets to the Supreme Court, it's very hard to do that without distinguishing Taylor and Novo, because you can't get over it. You can't say it's wrong, and therefore there is recourse to public policy. I don't think Mr. Justice Chamberlain would accept that that's what he was doing. No. What he would say he was doing, he would draw the macro-micro distinction that he identified in his judgment, and he would say, I'm paying due attention to Taylor and Novo, but it doesn't apply to this case because this case is a one-event case, I think is what he would say.
Yes.
I think he very specifically drew the distinction between himself and public policy and said he was not making a public policy decision. He was applying the control mechanisms. Yeah. Whether or not one is of the view he applied them correctly is by the by, but he is saying I followed exactly what's being said and I did that, and I'm not succumbing to a suggestion that I'm acting in a public policy way, or that this decision will have a consequence beyond its own ken within its own facts applied under the arc or the matrix of the public policy. And he referred very specifically to Renane and also to Shorter. And just to remind ourselves of the distinction of Shorter was a case where there was a relatively prolonged clinical event of a woman who had a severe headache, went to hospital, had a CT scan, and was told she hadn't suffered a subarachnoid hemorrhage, was sent home, and in fact she had, and 7 days later she came back to hospital with worse head pain and worse neck pain, and somebody re-looked at the scan and said, oh yes, in fact that was a hemorrhage, and of course her condition was significantly worse. Tragically, her condition worsened, she suffered a seizure and died. But the secondary victim claim arose from her sister, who in fact was a senior sister in the neurointensive care, so knew exactly what the consequences of a missed subarachnoid hemorrhage would be, and came upon her sister literally holding her head in agonizing pain and crying, and was fully cognizant of the fact that was an unfolding of a terrible event, as it later turned out to be. So she saw her sister clutching her head in pain, saying she was in pain, but she actually didn't see her dying. She had reported to her that she was gone into a fit, had seizures, and later died. Now that claim failed because the claimant argued it was a seamless arc, it was a seamless event that she directly witnessed, and it failed on applying that control mechanism. And so the very nature, the notion of the control mechanism put in place a check and a balance, and led to the claim not succeeding. While she'd seen her sister in pain, that wasn't a horrifying event, and she hadn't witnessed either the seizure or the later decline. She had those reported, so she had that mediated event. So she failed on those two control mechanisms. I mean, interestingly also that the test was said to be objective. So the fact that she knew very specifically what was happening didn't count. It's unlike taking a victim as you find them. It's not an objective test. It's not a subjective test. It's an objective test. So the extra knowledge that she had as a nurse, therefore understanding what she was seeing was very bad, didn't help her cause. Now that's quite a clear instance, and hailed by Chamberlain as one of the reasons why you can trust in the control mechanisms to prevent a floodgate opening.
For what it's worth, I don't understand why it's an objective test in that particular situation. If something is acutely shocking and sudden and acutely shocking to you because of your special knowledge, then I don't see why that subjective impact couldn't be something which allows your situation to pass the sudden and shocking test rather than not to. But that's a quite simple.
It is, but perhaps, Charlie, the reason they did that it was another control mechanism, I suppose, is the way of looking at it. Because you are going to reduce claims, aren't you, in that way?
Well, I think it's worth remembering the function of the control mechanisms is not simply to reduce claims. The function of the control mechanisms is to identify a situation where there is an appropriate cohort of claimants who can claim, and the provision of an objective test at that stage seems to me to be a step too far. But this is the problem with discussing this whole area of law, as I've said a number of times already, and I'm sorry I'm becoming rather boring as a result. It's not that public policy never has a role to play, it's that it can be co-opted by either side in support of an argument which otherwise wouldn't be available to them.
But I think we can also see from that sometimes the argument is adopted by the same arguments adopted by two judges to come up with different outcomes, which is neatly takes us back to where we started. Exactly the same arguments proposed by the defendant, and Taylor and Novo succeeds, and Paul and Wolverhampton doesn't, is one way of looking at it. But I'm conscious of the fact that we are able to discuss it for hours, and in fact we have discussed it for an hour. And the next question may be, where's my gin? I'm not sure, depending on what hour and yard arm to which you act. But it may be that on that happy note of public policy, we should think about wrapping up.
I'd like to say thank you to anyone who's still with us, in the literal sense, and we can't offer you that gin or indeed anything else except metaphorically, which we do. We extend the hand of friendship to all of you. Thank you for listening. If you have got any questions, please do send them in, and we will attempt to answer them. Thank you very much.
Thank you very much. Bye.
Bye-bye.
Bye.